Hello everybody, today is the 23rd of June 2021. It is the third seminar that we are hosting for this year. The speaker today is Yolandi Schoeman. Yolandi is the head of our bonds department. Yolandi is also an admitted attorney and conveyancer, and she's going to share her knowledge with us today, all about bonds. Thank you, Yolandi, and I hope you enjoy her talk. Thank you.
Good morning, everyone. My name is Yolandi Schoeman. I'm an attorney and a notary, and I also oversee the bonds department here at Jan L Jordaan. Today's discussion will be about bonds. Firstly, we're going to look at the definition of the bond, a bond. We're also going to look at the requirements for bonds and also the process that is required in registering a bond. To start, the most logical place would be to ask, well, what is a bond? A mortgage bond is a legal document. It is registered in the deeds office to secure an obligation on the part of the debtor, the mortgager, that is you and me, towards the creditor or the mortgagee, that is the bank. And it ensures the due and proper performance by the debtor to the creditor by securing certain assets of the debtor under the bond. In the event of any non-performance by the debtor, the creditor may approach the court for an order, which allows the creditor to attach and sell the property. The proceeds of such a sale will then go towards settling the creditor's claim against the debtor. Now that we know in general terms what a bond is, let's have a look in more detail regarding the following. How are bonds allocated by the banks to the attorneys to have it processed and registered, the various bond conditions that may be applicable, also the limitation on the registration of a bond or on bonds on properties, as well as the ranking of bonds. The bonds are allocated to attorneys via an auto-allocated method. Previously, where clients could nominate a specific attorney or a bond originator could nominate a specific attorney to do the bond registration. The banks have now become more strict in that regard, and very few of them actually allow for this to happen. So basically, if you are on a list of attorneys for the bank, it will follow the automated allocation. As a bond comes in, the next attorney in line will receive such a bond to attend to the registration thereof. Here at Jan L Jordaan Incorporated, we are proud to be long-standing participants on the panels of Absa Bank. Our panel number here is 2255. Also Standard Bank, we are on the strategic panel with Standard Bank. This means that we can do the bond and we can do the transfer. And the panel number is 3848. We're also on F&B's panel, and our panel number is 486. As well as Nedbank, with our panel number being number 7. We also have different types of bonds. You get normal allocated bonds, you get substitute of debtor bonds, you get switch bonds, etc. And each of these have their various bond conditions. Let's have a look in more detail as to that specific conditions required by the bank. Bond instructions. So each of these instructions will be different in that each may have different conditions. The bond will only be granted on condition that the purchaser's existing property be sold. A bond can also be granted on condition that the purchaser needs to take out life insurance to cover the bond in the event of any death. The bond is also granted subject to someone signing surety as a co-debtor, or in terms of sectional title properties, the proof of insurance must be submitted, and this is usually done by the body corporate of that specific sectional title. Then you also have a borrower's education certificate required for bond under a certain amount. Let's have a quick look at these different requirements. Just a few examples. In terms of a switch bond, you will see that the bank stipulates that there's a certain amount that they will cover of the bond registration cost. However, any amount exceeding that amount will then be payable by the client. The bank can then also direct us as the attorneys to reduce our cost by a certain percentage. Furthermore, in terms of a straightforward instruction, this is basically where a seller has sold off his home, and the bond that he has currently is with a specific bank, and where he cancels that bond and he applies for a new bond for the new property at the same bank, the bank might be generous enough to waive the 90-day early termination fee. In terms of sectional titles bond, like I said before, there's certain requirements specifically for insurance. However, in this one, there's a borrower's education certificate that is required, and this is where it's a new time or new homeowner, and In terms of the policy from the bank, it requires to educate the client as to exactly what the bond is, the terms and conditions thereof, also the obligations by the purchaser. And once they have attended the seminar that the bank provides, they receive a certificate which must then be sent to us so we can upload it with the rest of the bond documentation. And that's just to name a few. The ranking of bonds is also a very important matter to be cognizant of. Firstly, there is no limitation on the amount of bonds that may be registered over property. This is obviously provided that there is enough value in that property to register a further bond and so forth. Of the ranking of bonds. Bonds are ranked in a matter of security preference, where the bank holds the security as a main creditor from the initial bond. Any subsequent bond granted by that bank, you will still remain the main creditor and have that ranking. Whereas in effect another bank grants a bond over their property, then that second bank will also stipulate that it requires the equal ranking to the bank holding the initial bond. So ranking explained is that the first ranking creditor will be entitled to fill a full claim of outstanding debt against a debtor. The second and third ranking, although they might be entitled to claim a full amount, will only be able to receive payment after the first creditor has been paid in full. So in effect, you can see that the pool of funds left to satisfy a second or third creditor's claim is much smaller. There might be a chance that the second ranked creditor do get payment for his claims, and where a third party or third ranking creditor might not receive any payment whatsoever against its claims. Bearing in mind the nature of transaction and the seriousness thereof, that being the transfer of ownership of property, the law prescribes a very stringent process that needs to be followed. Let's have a quick look at the process involved. In terms of the process to follow when it comes to bond instructions, so firstly we receive the bond instructions from the bank. We have an 8-hour turnaround time in which to contact the client. Should we fail to contact the client within the 8 hours, this negatively impacts our scorecard with the bank. However, more on that later. So in drafting the bond documentation, we require that a draft deed of transfer must be sent by the transfer attorneys to us. The reason for this is that the full names and ID of the purchaser as well in the bond documents and the deed of transfer must correspond with one another. That said, also the property description in the bond documents as well as the deed of transfer must also correspond. The documents will then be submitted to the relative bank for an instruction to proceed. But let's first have a look at the ID details and so forth, as well as the property description in these documents. So the names and the ID of the purchase in the bond must correspond with each other. So you will see where the red block is, the names, the ID, and the marital status must reflect in the bond document, as well as in the deed of transfer document, and it must be exactly the same. It must correspond with one another. Furthermore, the property description in the deed of transfer must also correspond with the mortgage bond, the property description in the mortgage bond, failure of which will then result in a rejection in the deeds office. Once the bond documentation has been drafted, we can then contact the client for signature of those documents. Two things happens once the clients have signed the documentation. Firstly, we can then issue the guarantees as requested by the transfer attorney, and then we can also send all this documentation to the bank to receive an instruction to proceed. Stated these two things that happens. You can issue the guarantees. Let's have a quick look at what a guarantee looks like. This, for instance, is a plus guarantee. You usually get a plus guarantee, a minus guarantee, and a straight guarantee. A plus guarantee is usually where there is a settlement of a bond, and based on what is still outstanding, the interest rate that will apply. In here, you can see that they will refer to the account number, the client, the property description, and then a specific detail as to the amount payable with the plus interest. Here you will see it says the amount payable is that certain amount plus an interest at that specific rate. And then I said we will submit all the documentation to receive a proceed instruction from the bank. Now, proceed means that the proceed instruction by the bank is that they are satisfied with all the documentation that's been signed by the client and has been submitted, and all the requirements as stated previously in the bond with the bond requirements in terms of the educator certificate and all those documents have been uploaded as well, and we may proceed with the matter. Proceed with the matter means that we are going to lodge at the deeds registry's offices in that the transfer documents, the bond documents, and the bond cancellation documents will all be batched into one batch and will move through the process at the deeds office. In terms of bond registration, we have to notify the bank prior to 12 o'clock on the day of registration that the matter has registered. Should we fail to do that, then the guarantees won't pay out the next day, but it will only be paid out on the next day's payment run. So how the payment run works is that when we notify the bank before 12, the payment run runs at 3 o'clock that afternoon, and in effect payment will then reflect the very next day. Whereas if we do not advise them before 12 o'clock, the payment run will only be done the next day at 3 o'clock, in effect then paying out the day thereafter. A bond document is then endorsed with its own unique number and the title deed number of the property it relates to. I will show you an example of that now. The transfer document is then also endorsed with the bond number and the amount of that bond. As you can see here, it shows the bond. Sometimes they just handwrite in the deed of transfer number, and you see on the transfer side, it shows the title deed number as well as where it's mortgaged for the amount, and it reflects back to the bond, the unique number from the bond. This is in a nutshell a very brief overview of bonds. We've looked at the definition, we've looked at the process that it entails, we've also had a look at the intricate details that is required in registering a bond. I trust that you enjoyed the session with me, and I thank you for your time.
Thank you, Yolandi. That was very informative. I hope you enjoyed it as much as I did. Remember, by watching this video, you're entitled to a non-verifiable CBD point. Please contact Kim Schoeman from our office, and she will then see to it that a certificate is issued to you. Thank you. I hope you enjoyed it. As I said, enjoy the rest of your day, and we'll chat soon. Thanks. Bye-bye.